Here, we're exploring an area of law that's all about wrongs. Not crimes, but civil wrongs between people. You might not realise it, but tort law is everywhere. From a neighbour's noisy party to a famous celebrity's reputation being damaged by a tabloid. First of all, what does tort even mean? Well, it comes from a Latin word for wrong. Tort law is a branch of civil law that focuses on wrongs one individual does to another, not crimes against society as a whole. So if someone steals your bike, well then, that's a crime. But if they crash into you while riding it, causing you harm, that's a tort. And tort law didn't just pop up overnight. Most of it was built over centuries through common law, that is, judges making decisions in real cases. And way back in medieval times, people would bring trespass cases to court, like trespass to land or trespass to the person. So what is the main purpose? Well, it's to help a person who's been wronged, the claimant, get compensation or a remedy from the person who caused the harm, the defendant. Tort law's main goal is to put you back in the position you were in before the harm happened. Let's take a look at the main categories of tort, the main players if you like. Each one deals with a different kind of wrong. So first of all, we've got negligence, which is not taking reasonable care, causing damage. The key case here is Donahue versus Stevenson, and it established what we call the neighbour principle. You may have heard this case before. Mrs. Donahue gets sick after finding a gross little snail in her ginger beer. Now, the big deal here is that the court said you have to take care not to harm people who might be affected by what you do, even if you don't know them. And that's what we call the neighbour principle. Next, we have nuisance, which is unlawful interference with land use or enjoyment. And the key case here is the Hunter versus Canary Wharf case from 1997. So people living near Canary Wharf sued because a new tower messed up their TV signal. And the court basically said, not all annoyances count. Only certain types of interference with your property, like actual damage or loss of enjoyment, are covered. Losing your TV signal didn't actually make the cut in that case. Next, we have trespass, which is intentional, direct interference with land, persons, or goods. So we have the Collins versus Wilcott case here. So this was a police officer who grabbed a woman's arm without needing to arrest her, and the courts decided even a small touch can be battery if there's no good reason. So, hands off unless you're allowed. Next, we have defamation, and this means damaging another's reputation with falsehoods, with lies. And the key case is Monson versus Tussauds. So Madame Tussauds had put up a wax figure of Mr. Monson holding a gun, hinting he was a murderer. He sued for defamation, and the court agreed. It's not just about words. Anything that unfairly damages your reputation counts. Next on the table, we have Rylands versus Fletcher. And this is strict liability for dangerous escapes. Here, the defendant had made a reservoir that burst and flooded someone's mine. And the court said, if you bring something potentially dangerous onto your land and it escapes, that's water in this case, you're responsible for any damage, no matter how careful you were. And finally, we've got occupiers' liability. And this concerns the duty owed by occupiers to visitors and trespassers. So this is the Wheat versus Laken case from 1966. A man died after falling on a dark staircase in a pub. And the court said more than one person can be in charge of a place, an occupier, and have a duty of care. It's all about who controls the premises. There they are, a little summary. Right, okay, let's consider now the theories in law of tort. Why do we have these rules? Well, first of all, fault versus strict liability. What is fault-based liability? In fault-based liability cases, you're only liable if you did something wrong. something careless, reckless, or intentional. In negligence, the claimant must prove that the defendant breached a duty of care. But we also have strict liability cases. Now, here you can be liable even if you weren't at fault. If your pet tiger escapes, you're liable for the damage, even if you kept the cage locked. And take you back to the Rylands versus Fletcher case. That's the classic example. Consider then, fault-based systems seem fair and good at stopping bad behaviour, but strict liability makes it easier for victims to get compensated. Sometimes, though, it might seem harsh on more careful defendants. Economic justification of tort. Some legal experts, like Posner, who was a prominent American judge and legal scholar, argue that tort law helps society by encouraging people to act efficiently. If people know they'll pay for harm, well, they're going to take care to avoid causing it. It's all about minimising costs, kind of like managing risk in business. Critics say this approach turns justice, though, into dollars and cents issue, ignoring moral responsibility. Next, we have corrective justice. So this idea goes all the way back to the philosopher Aristotle. The main job of tort law is to correct things, to compensate the victim so that they're back to square one. For example, if you spill coffee on someone's laptop, you pay for a new one. Simple as that. Also, retributive justice. So retributive justice is about blame and punishment. It's more common, isn't it, in criminal law? But sometimes tort law awards punitive damages to punish especially bad behaviour. And some say this blurs the line between civil and criminal law because tort's main aim is compensation and not punishment. So some criticisms of the tort system. It's costly and slow. Legal fees and court time add up, so it's not always efficient. We may also have unequal access. Wealthier claimants or insured defendants often have the advantage. There's an emphasis on fault. If you can't prove fault, you may get nothing, even if you're clearly hurt. Also, at times, there's inconsistency in awards given. Damages can vary, and that makes outcomes very unpredictable. There's criminal law overlap too, so some courts, like assault or defamation, they're also crimes. And also we then have limited deterrence. Wrongdoers with insurance don't always feel the impact. They've got the insurance and they take the chance. So because of these issues, there are often calls to reform the system and make it fairer and more accessible. Here's a little summary there for you to pause and have a look at. And let's move on now to evaluation and reform. So theories of tort law help us see both the strengths and weaknesses of the system and why people call for reform. So let's do a quick pros and cons run through here. Let's start with A, evaluating fault. Well, the strengths of evaluating fault is that it encourages personal responsibility, fairness, and it fits in with corrective justice. However, in terms of weaknesses, it's hard to prove fault, it's expensive, and it leaves some victims without help. Reform idea, well, some countries like New Zealand actually use no-fault compensation schemes for things like road accidents so that victims can get help quickly. Next, we have evaluation of strict liability. So a strength of strict liability is that victims get compensated more easily, and it encourages extra caution. A weakness, though, it can be unfair to careful people, and it might discourage innovation. A reform idea, limits strict liability to high-risk areas like environmental harm or defective products. Next, we have evaluating economic theories. Well, the strengths here are that it focuses on efficiency, cost-effective prevention, and it recognises business realities. But a weakness, it may ignore fairness and the human side of justice. A reform idea, push for alternative dispute resolution, ADR, and insurance reform to keep the costs down. Next, we have evaluating corrective justice. So strengths, well, it matches tort law's traditional goal, which is to restore balance between people. Weakness, though, only helps after the harm is done and doesn't therefore prevent it. Reform idea, well, to move towards preventative law, health and safety rules, to stop harm before it happens. And finally, we have evaluating retributive justice. So here we recognise moral blame, and there's deterrence against especially bad behaviour. But a weakness is that it can confuse civil and criminal goals. Financial punishments might not necessarily fit the crime. A reform idea, well, some want to limit punitive damages to only the worst cases, and others want to use them to deter corporate misconduct. The big picture, balancing justice and efficiency. Tort law really is a balancing act. Fairness and individual justice on one side, and practical efficiency on the other. Theories like fault and corrective justice focus on fairness, while strict liability and economic theories aim for practicality. Modern reforms try to make the system faster, fairer, and more accessible. So, in summary, tort law is always evolving. Its theories don't compete, they work together to shape how society handles compensation and protection. The big question is, do we value fairness above all, or do we prioritise making the system practical and efficient? There's no single right answer here, but understanding these theories will help us think critically about the law and its role in society. So keep these ideas in mind and you'll be ready to tackle any essay or case study that comes your way.